Hello, everyone, and welcome. I hope you can hear me. My name's Giles Whittell. I'm an editor at Tortoise, and this is a think-in on a deceptively niche subject. So, as you will have seen, since you've been good enough to join us, the title is After Heathrow, What Next for the Climate Change Lawyers? But really, this is a way of looking at a much bigger question, and that is, I scribbled it down for myself, can we use the law as citizens to halt carbon emissions, if not climate change itself? Now, why are we doing this? Well, a few months ago, we hosted a think-in back in the midst of time when we met personally in Tortoise headquarters. It was not long, as I recall, after Extinction Rebellion had brought central London to a standstill. And with the greatest of respect to Extinction Rebellion, one of the big questions was, what were they going to do next? And one of our guests at the think-in was a lawyer from Client Earth. And she was very lawyerly, in a good way, mildly spoken, and explained in an unhistrionic way how she had been a part of the team that had forced the UK government to revisit all its air quality regulations and require 33 local authorities to do likewise, having persuaded the High Court here that the UK government was in breach of European air quality standards. And for me, and I think for a lot of people in the room, it was a scales from our eyes moment when we suddenly realized that while many of us in the room had been either on the streets demonstrating or cheering them on, this lawyer had quietly achieved something quite remarkable, not directly linked to climate change, but certainly to the quality of air and lives. And since then, Friends of the Earth, with the law firm Leigh, has forced the government, and I'm paraphrasing here a little bit, to abandon its plans for a third runway at Heathrow. The state of New York has taken on Exxon in a big and heavily prepared lawsuit in New York, which in the end Exxon won. And of course, COVID has taken over the world. But in the background, climate change rumbles on, and so does climate change litigation. And we've got some great guests from both sides of the Atlantic to help explain to us this evening what exactly is happening, what the prospects are, whether there are any silver bullets in prospect in the lawyers' battle with carbon emitters and climate change. And we'll get to them in a second. First, though, there is, as usual, a little bit of housekeeping. I suspect most of you have been to a real or virtual think-in before, but the main point is that we want to hear from everybody. The distinction between panel and audience is so blurred as to be non-existent. We are really serious about harvesting these think-ins for story ideas so that we can pursue them and publish stories on the Tortoise app, and in particular in the case of this subject, where the climate lawyers are going to go next. And so do get involved. You can do that in two ways. You can type in the chat, where my colleague Barney has welcomed everybody, and where one of our speakers, Joanna, has already uploaded a link to her latest overview of the state of climate litigation in the UK. I confessed to her a few minutes ago that the last version I read was from 2018, so it's good to have an update. And you can also get involved by clicking on participants at the bottom of your screen and raising your digital hand. And so let's have a little practice there. Who knew that private litigation was one of the main reasons that the UK government and Heathrow itself has abandoned plans for a third runway at Heathrow? Raise your blue hand if you knew that. it's good to see some of our Moonshot 2030 people up to speed on that. Thanks, Sophie. Thanks, Yelena. But it's a relatively small number. Okay. Who thinks, and this is a new question, so you can lower your hands. Thank you very much. And this is getting ahead of myself, that climate change will, or some aspect of it, will become the next big tobacco in litigation terms? Or are we, is that wishful thinking? You're raising your hands if you think it will. Okay, again, a small proportion. Okay, well look, let's move swiftly on. One of our guests, Rowan Smith, is a solicitor at Leigh, and I'm summarizing what must have been a sort of titanic chapter in your life, or I like to think it will be depicted as such when the movie gets made. You helped defeat plans for a third runway at Heathrow. Is it possible, briefly, to tell us how you did it?
Thanks, Giles. Hi, everyone. Yes, yeah, I can give a snapshot of where we've got to with the Heathrow litigation.
It's still subject to appeal, right?
I was just about to say yes, yeah. So the current state of affairs is that after a successful Court of Appeal judgment, Heathrow Airport Limited, which is the company making the bid to build the third runway, they received permission to appeal. So we're preparing for a hearing in the Supreme Court for later in the year. Interestingly, the government hasn't appealed, and as things stand, won't participate in the appeal when it comes to the Supreme Court.
So the appeal, sorry, the appeal will be by the airport itself.
Yes, exactly, Heathrow Airport Limited.
Yeah.
Yeah. So make of that what you will. I mean, I think the Prime Minister was always in a compromised position on Heathrow, obviously, right, given his opposition as a constituent MP, and possibly, and others might have a view, the government saw a fairly easy way out, because it could say, we've been told we're not allowed to do this by the Court of Appeal, even though we want to, but it's up to industry to make the case, which you know is a fairly good way out of avoiding responsibility.
But nonetheless, I can see the political argument that it was an easy way out for a prime minister who'd said he'd lie down in front of a bulldozer to prevent that particular runway. But by the time they chose not to appeal, the government had suffered, or the project had suffered a pretty resounding defeat, had it not. I just wonder, what were the secret weapons? Somebody had the bright idea of using the Planning Act. Is that right?
Yes. So the case had to be brought through the Planning Act, because that regulates how decisions on big infrastructure projects are made. Mm-hmm. So so decisions to do with the planning and environmental system are made both at a local level and a national level. And when it comes to decisions made at the national level, there's a specific way that those decisions are made, including what's called a national policy statement. Right. And that was the policy document that we challenged in the litigation, because effectively that gave parliamentary green light for a third runway. and how we managed to think creatively about constructing climate change legal arguments was very much governed by the legislation, by the framework created by this Planning Act, because there's a provision in there that says in producing a national policy statement, such as the one on airports and Heathrow, the Secretary of State for Transport had to pay regard to the need to mitigate and adapt to climate change. And in doing so, had to adhere to sustainable development duties. So as lawyers, that was our way in, because we were able to construct the argument that what that meant was that the government needed to look beyond its target under the Climate Change Act and had to look more ambitiously to the targets under the Paris Agreement.
Right. And that requirement within the Planning Act was introduced in 2008, is that right?
Correct, yes.
And the judge at the appeal court was quite rude about the Secretary of State, wasn't he? And as those tuning in from across the Atlantic may not be aware, the Secretary of State at the time was Chris Grayling. Do you think you got lucky that he was in the chair at the time?
Possibly. I think whoever the Secretary of State was, they were poorly advised. Because
that's very diplomatic of you.
Because how the government's defence unravelled was that we made an application to the court for copies of all documents that may have mentioned the Paris Agreement. The government was unable to produce those documents, and to save the embarrassment of effectively conceding that they had just completely ignored the Paris Agreement, they conceded that their advice from the civil servants was that legally the Secretary of State didn't need to look at the Paris Agreement. So the litigation developed fairly quickly into a stark positions. On the one hand, Friends of the Earth arguing that these duties made Paris a mandatory consideration, and the government, on the other hand, saying they were lawfully entitled to ignore it. So that's why the Court of Appeal's judgment was fairly crisp and critical, because there was a binary choice. Did the law say this or did it say that? And it came down on our side.
Now, it seems in a sense a narrow legal point, but it's huge as well, isn't it? Because there's been a great deal of a sort of big picture, non-legalistic debate about whether Paris is legally binding on nations. And when it comes down to it, I thought that the answer was that it is not. But has the appeal court effectively found otherwise?
Well, let's see how it's dealt with by the Supreme Court. But yes, on one reading, international agreements such as the Paris Agreement or any other United Nations agreement is not directly binding on the UK on the UK government, because we have a dualist system of international law and our own domestic law.
Yeah. So
in order for international law to be directly applicable, it needs to be implemented through domestic rules. This judgment is very interesting because some would argue it in practice, the judgment in effect puts international law on the same footing. So it's potentially a backdoor route to enforce those rights under international law.
Right. Just one final thing. Do you personally think that the Supreme Court will uphold the appeal court's ruling on this, or does it keep you up at night?
Well, I think we're confident as we can be. I think the government not appealing probably speaks volumes, and
Right.
doesn't put the Heathrow Airport Limited on a very good starting block.
Right.
I think, as I said before, because it's such a stark point, take Paris into account or not, I think that the Supreme Court is perfectly capable of realizing that a international agreement that was so pivotal in climate change had to be taken into account, and to completely ignore it, the common sense conclusion is that was unlawful.
Right. Thank you very much. Let me move on to Joanna Setzer, if I may. Joanna, you are a associate professorial research fellow at the Grantham Institute at LSE, and also currently, if I'm right, working on the IPCC's 6th assessment review, and specifically on climate change litigation. Now, as I was saying, I was reading your 2018 review of climate change in progress, in which you, if I can summarize in one line, you conceded that the first wave of landmark climate litigation cases in the early part of this century had broadly failed, in that courts had not found in favor of the complainants or plaintiffs, but that a second wave was underway. Now, how is the second wave going?
Yeah, so, well, the paper you're referring to is a paper we were looking particularly at litigation against carbon majors. But I think broadly, we can see these two waves of climate litigation, with 2015 as a landmark between the two waves. So let's say between the first cases that were brought in the late 1980s and 90s until 2015, there was quite it was more experimental, but not very successful in general. Litigation was very concentrated in the US, with some cases in Australia, some in Europe, but very, very much a US phenomenon. The one successful case against the government was Massachusetts versus EPA. No cases of success against private companies. So we get to 2015, and there's this landmark decision in the Urgenda case, which I don't know if everyone is familiar with.
No, I doubt it. So do please say. I don't mean to insult anyone participating, but I didn't until recently, so do say what it is.
Great. So the Urgenda case was a case brought in the Netherlands by an NGO called Urgenda, relatively small NGO. Urgenda stands for Urgent Agenda. And what they did was a very bold case challenging the Dutch government for not doing enough, for not being ambitious enough, for not having targets that were what Urgenda said they would expect from a wealthy country that should take the lead. So in 2015, there was this first decision that a court tells the government, you're not doing enough. And that was groundbreaking, because if you think about separation of powers and how usually judges and courts are reticent in saying something like that, the fact that they did so, and this was a district court, the District Court of The Hague, was already big news, and it opened the attention of many litigants around the world. So this is a case against the government. In 2015, the government appealed. In 2018, the Court of Appeals basically not only confirmed the decision of the First District Court, but also the case then shifted more significantly towards human rights. So to understand that protecting the climate was a human rights issue, and that the government had a duty of care to protect the climate and the Dutch population. And the case went all the way to the Supreme Court. And just now, a few months ago, in December 2019, the Dutch Supreme Court then decided, again confirming basically the two previous decisions and telling the government, you need to do more, there's no excuse. So that was the big case, I think, in the story of recent climate litigation. And that was a successful case that inspired many other cases that are being brought against governments. And the case that we're discussing here today, against the government and also Heathrow as a company, as a group, but it's very much inspired by your agenda. So this is one part of the story, and the other part of the story is the one you mentioned, that are the cases against companies, and then there are many different grounds that we are observing. We are still in that second wave where we don't have so many successes, but we see how different strategies are being used and how some have been already quite impactful. And
which have been, of the new emerging strategies, and you were already noticing 2 years ago that the fact that the science was becoming more robust was having an effect in the way the courts ruled. Which of the new emerging strategies do you think is going to be most successful?
So I think the kind of low-hanging fruit that has already been quite interesting to observe are greenwashing cases. Mm-hmm. And you mentioned Client Earth when you were introducing this talk today. And Client Earth recently brought one of these cases. It's not a judicial case, but a complaint against BP for greenwashing. Basically, BP saying that they invest, apparently you would think from the advertisement campaign that they are doing so much on renewables and clean energy, but then you look at how much they invest and it's so little. So it's this type of inconsistency, which again, you know, the idea of inconsistency is very much present in this Plan B case, where you will challenge the government saying, look, you go to Paris and you say you're doing so much, and then you come back home and you approve a new, the expansion of an airport. So in this regard, it's similar, that we're challenging inconsistency of governments and corporations. And basically this greenwashing case was, it's an easy one to win or to show to a wider public, if you're thinking of a litigation, not only as a one singular case, but as a wider campaign strategy, an advocacy strategy, that basically these companies are fooling people, or you can't trust what they're saying. And this is the kind of case that now we see also in the US. There's been a recent then litigation case brought by the Washington, DC, and with Wisconsin against carbon majors, where again this idea of greenwashing is being brought. So this is something that I think we can all understand and relate to. And then you go all the way on the spectrum to really challenging, amazing cases, such as the Peruvian farmer. There's a really interesting case that was brought by this Peruvian farmer who lives in the Andes in a tiny village, and he files a lawsuit in Germany against RWE, which is this huge German electricity company. And what is argued in this case is that the impact of this company's emissions in decades basically result in his village being at risk of being flooded. And this is where you mentioned the idea of science. This is where we see how climate science has been really crucial for this type of case, because you can't just show how much you're investing in clean energy and that this doesn't correspond to your advertisement campaign. You really need a strong, robust science to say that your emissions not only cause global warming, but they are impacting this village in the Andes, and therefore you can bring that case. So this is really advanced science, and this is where climate attribution plays a big role.
Right. Now, I should know, but is RWE active in Peru, and was the Peruvian farmer acting with the help of a local NGO?
Yeah, it's a good question. So the Peruvian farmer was supported in this case by a German NGO, right. German Watch, sorry. And so basically he came to German Watch at the time that there was a COP in Peru and told his story. And the German NGO said, we want to support you. And
sorry, at the time that there was a what in Peru?
Sorry, a conference of the parties. So a UN meeting where you have all the heads of states committing like they did in Paris.
Right.
And in this case, really, I think it's a very, if you want people to understand what climate change is about, is very much that, right? It's the person who is most vulnerable suffering the impacts of something that is completely beyond his control. And so this case was, it's one of these test cases in that it's a very challenging case to win, but they've passed the first barrier, let's say, and the case has progressed into this, basically a phase where they have scientists trying to make sense of it. But RWE, you asked me if they operate in Peru. It's a good, I don't think so, to be honest.
So the case is, just to be clear, the case is being brought on the basis that this being a global problem, then any emitters' actions anywhere have global consequences. And that's why the science is key, right?
Yes, yeah. That's the key to the case.
All right, well, look, thank you very much. I'm sure we'll come back to aspects of this before the hour is out. As you mentioned, initially, and it's still the case, the bulk of climate litigation is in the States. And Tyler Maroney is not actually a lawyer. He's formerly a journalist, like some of us, and is a co-founder of Quest Investigations. And you're a PI. You're not actually wearing a Mac or a sidearm, but you're also the author of The Modern Detective, a book out later this year in the States, and we hope subsequently elsewhere. And Tyler, you were saying before we started that about a quarter of your work, your company's work, is broadly speaking in climate litigation. Can you give us an overview of the climate litigation industry, if you like, from where you sit? I mentioned that the widely noticed case, State of New York against Exxon, for the time being hasn't gone anywhere. But what was surprising from our chat earlier is that by no means has discouraged litigants in this field, has it, in the States?
No, I think that's right. And first of all, thank you again for having me to be part of this. It's an important conversation. I will say, as a non-lawyer, I have the luxury of not being asked to explain legal precedent and the laws surrounding this nascent field. But I will say, to your point, Giles, that there are a number of different tactics and strategies that are being used in the US. I'll give you a few examples. One is a very famous case that's referred to as Kids v. Gov, in which a number of children sued the federal government, claiming that the government was violating their constitutional rights to life and liberty and not protecting the natural resources, quite literally not protecting the oceans and the mountains where these children live. Another example is, and this has also been mentioned, the Attorney General of New York sued ExxonMobil. And in that case, the allegations were that Exxon was lying to shareholders. So it was essentially a securities fraud case. A third component of these are cases in which the plaintiffs are other municipalities, so cities or counties or whole states suing fossil fuel companies and sometimes trade groups alleging that they knew that global warming was real and failed to disclose it. But further than that, actively engaged in deception. And I think that's a word to keep in the back of our minds here, is what's in common in terms of many of these. Although the plaintiffs vary from children to municipalities, there is an overarching theme of alleging deception, of alleging misstatements, of alleging, engaging in a quite literally decades-long campaign of climate denialism and the rest. And the role that investigative firms like mine play here is to try to put some meat on those bones, to try to find witnesses who can testify to that fact, or to gather documents that help prove that. So in that sense, our work is very similar, even if our clients have a different legal claim.
And talking about the Exxon case, in a sense, it was on that technicality that took it into the securities fraud territory. But as you say, it was the underlying allegation was deception for many years. Do you think the fact that the court in that case found for Exxon has put that argument to bed, or in the many dozens of cases that are still being pursued elsewhere in the States, is that still essentially the argument that is being advanced, that companies that knew withheld information or distorted it?
I do think that even in the face of an unsuccessful proceeding like that, there is still the feeling in the States, in the legal community, that this movement, to call it that, is gathering steam, and that the momentum is really gearing up at this point. You mentioned tobacco earlier. I don't have the exact number, but as most people on this Zoom know, there were quite literally thousands of lawsuits in the United States, and eventually they started to gain steam. And people eventually kind of came out of the woodwork to testify to the fact that the tobacco companies knew that their products caused cancer and buried that fact for decades. The case in New York was interesting because it was so high profile, and it was the first time that many executives, like Rex Tillerson, for example, who had been the CEO of Exxon and then Secretary of State, had to show up and testify. And so that was a kind of thrilling moment for many people who follow this work, to get the people who are at the top of the food chain to come and explain their side of the story.
Right. But is there a big hurdle still to be overcome in terms of what I believe is called standing? And as you say, you can defer to lawyers on this if you want. But as I understand it, hitherto, even the high-profile cases like this have in a sense fallen at the first hurdle, because judges, some of them clearly and sympathetic to the cause, have said, "I'm sorry, this is a political case. It is essentially to be heard on Capitol Hill, not in my courtroom."
That's right.
I mean, are you still waiting for one of these cases to surmount that hurdle?
I think that's right. And in the United States, that will happen when we get past any motions to dismiss into discovery in a civil case like this, where both sides have to essentially share all of their internal documents, so to speak. Is that answering your question?
Yes, and have none of the cases got to that point yet? Well,
I mean, there was a trial in the New York versus Exxon case, but that was very narrowly a securities fraud case.
Right.
Which, and I don't mean to downplay it by saying narrow, but they had to prove that the officers and directors of Exxon knew that they were misleading people, and that's very hard to do.
Right.
Because if your defendant is a gigantic company, it's not an easy exercise to go through. But to put maybe a finer point on my previous point about this issue of deception, I think what's often misunderstood is the idea that many of the plaintiffs are not arguing that fossil fuel companies were aware of global warming and are the cause of climate change. It's more specific and creative than that. It is that they misled the public, or that they engaged in active deception around what they knew. In other words, taking it one step further. And so that's where some of the more creative legal thinking is going on. But again,
Okay.
as a non-lawyer myself, as someone who works for lawyers, I would likely defer to others to put a finer point on that.
Sure. In a moment, I want to come to someone who's identified in the chat as James's iPad, because you've raised the issue of other cases currently being pursued by Client Earth, and it'd be good to know why you think they're significant. But I'm not done with you yet, Tyler, I'm afraid. I know that there are cases that you're working on and you cannot talk in specifics about clients or identify them, but give us a flavor of the kind, I mean, you've said that the kind of work that you do in these cases involves finding people and documents. What sort of people and what sort of documents? What one of your investigators, what would a typical day involve? Might it be debriefing a potential whistleblower? What's it like?
Great question. So the reason we do this work is because we believe in it. And in a way, we kind of reverse engineered the business development of a professional services company. Most lawyers and consultants are opportunists, right? I mean, they take what they can get. Well, we thought to ourselves, how can we use our skills doing investigations to benefit, to quite literally save the world, right? I mean, I think that's what everyone's trying to do in a way, not to be melodramatic about it. And so we have various tactics that we use for litigators that involves, as you suggest, finding people, for example, former employees of defendants or former employees of vendors to those defendants who knew about the kind of actions that have been alleged, and to interview them, which of course was much easier pre-COVID.
Right.
And in addition, finding documents, which is, often, as you suggest, whistleblowers are incredibly valuable because they might have some internal document that they hand to you. But most of the work is actually very creative, kind of public records searching. And this is much easier to do in the United States than it is anywhere in the world, because we have not nearly the respect for privacy that most countries do. And so we can find, litigation and property records and securities filings and the like that most people are not paying attention to. And we're able to find those documents and within them, the clues to help make the case that the plaintiffs are making.
By the way, on that, are there any US laws that make it possible, if not easy, for you to pursue those kinds of records outside the US as well? Are
there laws in the US, or is that
yes? Well, I mean, I forget the acronym, but Congress is not known for its modesty. It often passes laws that it asserts apply everywhere. And I'm wondering if any of the that taste for disclosure, distaste for secrecy that you mentioned in the States, which I'm a big fan of, sort of pushes its tentacles into other jurisdictions to help you investigate internationally.
It's a great question, and I don't have a smart answer for it yet because our work has not gone that way, but it's very clear that this work is becoming more and more global. As the example that Joanna gave of the Peruvian citizen, as a plaintiff suing a German company. So, and many of the companies that are involved in this behavior, or the countries, the defendants, this is not all about the activities, the allegations against fossil fuel, but it is about governments as well, failing to protect people. Having known about climate change literally since the 1950s and 60s. But in terms of your question about international reach, that is not an issue that's come up in any of our work yet.
Okay, thanks. Well, I said we'd go to James. You mentioned Client Earth's case in Poland and also Greta.
Okay, it's James Cameron.
I see now.
Yeah, hi. Sorry, I should realise what my James's iPad thing it looks to you. Yeah, so just I'm a barrister by training. I taught law as well as practice for many years, and way back in 1989, I helped to found the Centre for International Environmental Law, who is active these days in exactly this field. And I advise a foundation called FILE, which funds climate litigation around the world. And I spent 30 years doing the climate litigation and negotiation, so that the connection between the Paris Agreement and the case at the Heathrow was particularly pleasing to see. So I feel confident in saying that this is a movement of ideas that is gathering strength and recruiting very capable people, both on the formation of the scientific and evidentiary arguments and the legal arguments that could be effective in many different fora, many different types of cases. And I see this as being a necessary adjunct to all the other interventions we need to make in the law creation process, in public policy making, in consumer decision making, and just generally speaking, what you do, tell stories that engage the public in the feeling that this problem can be solved with their participation, with their focus on how to stop the actions that cause harm, how to encourage a transition to something that could be sustainable. And the law is an absolutely vital part of that transition. So yes, I see lots of opportunity, and the range is very interesting. The human rights cases, the case, for example, the children's petition that Greta is a part of, that clearly addresses both the unfairness, the intergenerational unfairness that climate change presents, and the sort of deprivation of the basic human rights that we enjoy, that comes from the failure to deal with this problem adequately and in time. So there's urgency there. You've heard about the agenda case, and that is very inspiring. But there are lots of technical cases coming forward. There are planning cases on coal. There are shareholder actions on coal. I think that Client Earth case in Poland is really interesting, that they were able to join in a shareholder discussion and make the point that further development of coal is just bad business. It destroys value.
Is that case concluded, or where is that going?
It's gone. They were successful, and the company has actually taken on board that judgment and charted a different course. I don't think there are going to be further hearings. That there might be others on this who would be able to tell you whether that there's going to be any further action. But at the moment, it seems that victory has led to a change of mind in the company itself, and so much the better. There are lots of opportunities to take litigation, win or lose, change the nature of the discourse, both at the public level, but also with the company concerned. Because increasingly the alternatives to those activities which cause harm, for example, fossil fuels, are attractive to investors, are attractive commercial alternatives. And so one outcome from successful pursuit of a case could be just a changed course in a corporate actor, and that as long as it produces the end result, then that's a form of success.
Two questions arise. Do you think that ultimately, and particularly, I guess I'm thinking in the States, the effectiveness of climate litigation needs to be measured, in changed behavior as opposed to concrete legal victories, and in which case this use of law would be as a deterrent rather than as a sledgehammer or a stiletto? Do you think that's where we're going?
Yes, I do, because that's why I emphasize the change of consciousness. Lawyers have to focus on winning their cases as best they can within the tribunal that they're addressing, really very focused on who that tribunal is and how you get to win. That advocacy comes in a very particular form, and it's quite hard to understand, from an outside point of view. and it's worthwhile winning in that context. But you have to win in another context. Your advocacy has to be successful both in the courtroom and out of the courtroom. And out of the courtroom, again, a particular form of advocacy operates in parliaments and in parliamentary processes in the political realm. But another form of advocacy operates in public discourse where behavior might change independently of any particular intervention by a government or a court. But the language of the law is still very powerful. Mm-hmm. Rights, wrongs, duties, responsibilities, fairness, those are all concepts we can understand and own as citizens. They're not ceded to other people to determine for us exclusively. And I like the idea of the climate litigation, the movement, which has been referred to already, making citizens feel empowered to make claims or to pursue advocacy in a broader sense of that word. And that is definitely what will happen when generational shifts take place in the States, and this issue becomes, a matter of common understanding of what is right to do, especially when the alternatives are attractive. And you need both, I think, for a big transformation. It can't just be, oh, you mustn't do that, it's wrong. It must be, if you do something else, it's not only right, but better for you. The future looks good having solved the problem.
Right, thank you. I see in the chat that Jill Ruddick is broadly agreeing with what you're saying and making the point that somebody needs to alert the mainstream media to the fact, as you put it, that it's possible to make progress towards mitigating the actions of companies and governments. I guess, Jill, you mean it's possible to make progress without actually thumping them in court. But I wonder, isn't there, isn't it still worth pursuing that thumping victory on the steps of the courthouse, an equivalent of the great class action victory against big tobacco, as a galvanizing point? I mean, I fully accept the argument that climate litigation may be ultimately a movement rather than a weapon, if you like. But wouldn't it be an extraordinary moment in history to score a big victory in court?
Absolutely. My point really was that it comes back to the first question you asked on this ThinkIn. How many people knew about the reversal of the decision on the third runway in Heathrow? And it wasn't a very large number, as I recall. And I think my point was it's how we can, because good news is no news, as we well know. And all of this is good news, but it's a question of, James was talking about the need to empower people, the need to engage them, to actually make them realize that they can make a difference. And it's somehow getting hold of the media in such a way that they will be, they will help broadcast the successes of the legal community. So that was my point. Right.
And in fact, that was, I'd just like to come back to you, James. Would you be satisfied that the climate litigation movement had done its job if it was measured only in sort of incremental changes in behavior, as distinct from, say, a massive class action win and a payout in the billions?
Not either or. I mean, I'm all in favour of pretty aggressive challenging of failure to act, and I'm all in favour of proper recompense for harm caused, even though, let's face it, all of us in our various ways are complicit. But that's why many of these cases are to do with really egregious behaviour that does need to be called to account, especially when shareholder money, our money ultimately, if we have a pension, is often, or has been in the past, spent on increasing risk to us in the various campaigns to prevent the proper regulation of greenhouse gas emissions. So I'm not for being too nice, but I am aware that the range of legal actions provide many opportunities for sensible compromises and trade-offs and marginal improvements and incremental changes in the way the financial system is regulated and more disclosure and more accountability for quite small things, which when you add up amounts to a transformation. And the transformation we have got limited time to do,
Right.
but in some sectors of the economy we've got a bit more time. Aviation, we've probably got we've got some time to make that fix. And in power, we're winning anyway. So that's all about accelerating the shutdown of coal and making sure that it's just not smart for people to continue to invest in things that cause harm.
Right. Before we run out of time, I do want to come back to Joanna and Tyler and Rowan and back to the original question, which was what next? And Joanna, perhaps I could come to you. Looking forward to 2030, do you anticipate in this country or indeed elsewhere, other areas that you've studied climate litigation, that we will be talking about new landmark cases or indeed studies? One thing I wanted to ask you about earlier was the significance or otherwise of this, the carbon majors study in 2013. Is that something that that could still be influential going forward? And then the other question, what do you anticipate in 2030? I mean, it's impossible, I realize, to predict what the next landmark case is going to be, but what are you watching most carefully?
Sure, thanks, Giles. Well, first with the carbon majors question, I think that
Can you tell everybody briefly what it was?
Sure. So that was a study that was published in 2013 by a guy called Rick Heady. He was not an academic, really. He was working independently. He's almost like an accountant who spent a lot of time gathering information on historical emissions of the major energy companies in the world, oil and gas and cement. And what he did was, as an accountant would do, he started adding up numbers that were out there and that maybe we didn't have them together, all the way to post-industrial revolution. So all of a sudden you had a list of 100 companies that exist for over 100 years. Many of them just changed names, but you could trace those emissions back to over 100 years ago. And adding all of those emissions, he was able to say that that small group of companies, 100 is not a huge number, responded together for over 2/3 of global greenhouse gas emissions. And that was somehow a missing piece for a lot of litigation, in that we would say, yeah, we know these companies are emitting a lot, but you didn't have numbers, you didn't have a ranking. And just having that list with how much percent each one is responsible for was very helpful for a number of cases that then followed that still you have the missing part of the attribution, which I mentioned, but at least to have a list of names of companies, that was very important. Of course, there are people who questioned his work and his methodology. He continues to update his work, and that's still being used in some of the cases, including, for example, the Peruvian farmer case that I mentioned. He asks for 21,000 euros only from RWE. And the way he got to this number is basically, this is the proportion that RWE emits, then translated into the works that he needs to protect his village. So you see how that study is being used in litigation. It continues to be used, and it's not going to be the only one. There will be more studies, updates of this study that will definitely be important for future litigation. And then this takes me, I think, to your next question: where do I see litigation going? I was a lawyer in my previous life before becoming an academic, and the reason why I decided to quit my life as a lawyer was that I was a litigator back in Brazil, and I just didn't believe that going to courts and spending so much time and energy writing those appeals and questioning and then petitions, whatever, that was going to make a change. So I abandoned my career as a lawyer, an environmental lawyer, went into academia to study policies and see how other tools and mechanisms would be more effective than basically going to courts. And then by the end of my PhD, I realized that actually I think there is a role for litigation, there's a role for courts, and that was the beginning of this new wave of litigation anyway. And it's been fascinating to see how new ideas are being developed, how science and law are in conversation, and one is supporting the other and translating to the wider public. And as James said, also empowering people as they become part of cases themselves. You have a number of these cases. The Urgenda case, for example, is Urgenda plus 800 Dutch citizens, and there are a number of other examples, such as this one. So litigation, climate litigation, of course, you still have the routine cases that you will be questioning something, a permit that was given that asked the company to do this or that, and you go to court and there's something with climate in the case. That's also going to continue to increase, because more and more a developer who wants to build a hotel by the sea is going to be asked to consider what happens if sea level rises, if they are prepared for that. So you can see how climate change will be part of smaller cases. And I think this is also something important to take into consideration, because it's not all about big Urgenda Juliana cases. I think everyday cases that will and are already looking more into the effects of climate, of droughts, of rainfall, extreme weather events are going to and are already becoming more part of people's lives. So in everyday cases, I think we'll see more climate, we'll see people knowing that this is something they can bring a case, and also judges knowing that this is important, not being afraid to maybe make decisions that consider, okay, so I can give a decision that acknowledges that climate change is happening and not just run away because this is something scary for scientists. And then also bigger cases, these strategic cases that are really crafted and thought through, and they're creative and they're fun and they're exciting for, you know, for journalists and academics. But I see both, and not only in the US and in Europe, but also in the global South. I've been writing and studying more litigation in the global South, where people suffer they have different challenges. They have, through litigation, they aim different things that what you will see in the global North. So if you think about deforestation in the Amazon, that is being a problem in decades. And so many cases were brought based on just the deforestation on like the forest code, but now are being thought also in the wider climate impacts, global impacts. And just to finish, I think this is also linking to the Plan B case, Heathrow. This is something that the case also showed, how until recently you were discussing such a story, such a problem based on NIMBY, so people who live near Heathrow and don't like the noise and don't like the look of the airplanes flying. And then you bring that to a different dimension by saying, look, it's not just about the people who live around and might not be happy with that. There is a real global effect about all these airplanes flying. And this is something that people now understand and relate to. And I think that's the same with the deforestation and other problems in the global South.
Thank you very much, Joanna. I'm sorry to start muttering like that. It's just running out of time. Tyler, yes, let's come back to Tyler. You wanted to make a point about the media, and then I see we have a couple of hands up, and we'll try and be very quick.
Well, thank you. I just wanted to thank you, Giles, for putting on this this event, because I think it highlights a good trend in what's happening with the media. I sometimes fear that there's too much alarm bell ringing in the media, like stories about a tree frog in Costa Rica that has gone extinct, or a glacier that is melting. And not to suggest that those stories aren't important, but I think some coverage of what are we doing about it, whether it's through litigation or activism through groups like Extinction Rebellion and Sunrise Movement, you don't have to ring the alarm bell for anyone who is a member of any of those groups. You know, the younger generation is on board with the fact that climate change is real. So I just wanted to thank you for having this conversation, because the more the media can talk about what, not writing articles about the debate around climate change, but simply what has happened and what can we do moving forward. So that would be my answer to what comes next, because often what's happening in the courts is not necessarily what's being reported in the media.
Evidently. Thank you. Rowan, what are you up to now, if you can say?
Well, obviously the Heathrow Supreme Court hearing, there are a number of other cases to do with fossil fuel extraction. The Cumbria coal mine case and the Surrey oil extraction in Horse Hill are two examples of ongoing litigation in that area. And of course, also the Drax case taken by Client Earth. I liked Tyler's description of deception. And I was just thinking about what's the new deceit. And from our perspective, what the government is now trying, I mean, the government is wising up to Paris. It's fairly inescapable that any decision made at central government level that will have a climate change impact, inescapable that Paris needs to be considered. I think that's fairly certain now. But the new deceit is what happens between now and 2050, because the government is trying to say that the totality of its climate ambition can be reduced to net zero. And provided by the time we get to 2050, it's net zero, then that's fine. So that, I think that's how they're going to defend these cases that are coming forward. But what that misses is what you do between now and 2050. And obviously, with stranded assets in the fossil fuel industry, with committed greenhouse gas emissions between now and then, a lot of damage will obviously still be caused. So the legal argument, I think, is going to shift very quickly onto Paris being relevant to how does Paris impact on how you get to net zero between now and 2050.
Thank you so much. And I'm sorry that we didn't have more time at the end. And Maya, I see you have your hand up. I'm really sorry that I didn't get to you. But let me very quickly say thank you to everyone. Thank you to Joanna for pointing us to the Peruvian farmer. I can see that will have been reported heavily in Germany, but I want to look into it here. Thank you to Rowan for making the point that Paris's status might not have been defined in law at the time, but it's gelling in law now. Thank you, James, for making the point that, and Jeremy, I noticed in the chat, that the law can be a movement, not just a weapon. It can be both. And thank you everyone for pitching in. I'm sorry that we didn't get to everybody, but I think this is really fascinating and it's nice and granular. And I promise we will be identifying auspicious journalistic angles and pursuing them at Tortoise. Thank you very much. Please join us for SenseMaker Live on Friday lunchtime. And if you can't make that, have a great summer. Thanks a lot. Bye-bye.